Indigenous peoples from across Turtle Island, and we are grateful to have the opportunity to work and learn on this land. Now, last month, Martin Friedland celebrated his 90th birthday. It's hard to believe. But true, 90. So we thought that a milestone like that merited celebrating along with a simply extraordinary person. It goes without saying that former Dean and University Professor Emeritus Martin Friedland's illustrious career has been and continues to be driven by a pursuit of wide-ranging scholarly interests, and it's been celebrated through countless prestigious honors and awards. His many contributions, and we can really only scratch the surface here today, are personal because he's served as a dedicated and influential mentor to so many of us here today and many, many others. His contributions are institutional. Since the time he was dean of our faculty, he has remained an active member of our community and generous with his unique insight and wise counsel. His contributions are in public service. He's served on numerous government committees, commissions, and so on, too numerous, quite literally, to list. And above all, he is world-renowned for his scholarly work, ranging from his groundbreaking work in criminal law to his incisive histories of the University of Toronto and of the first Dean of Law, Kennedy, about whom we will hear a little bit more today. Now, as you can imagine, it was actually incredibly easy. It's not normally easy necessarily to recruit people to come and participate and speak and engage in an event, but in this case it was easy. It was extremely easy to get friends and colleagues wanting to participate, and so we thought what we would do is celebrate Marty's many, many contributions with a sampling of the colleagues and friends whose careers and work he has helped shape. And of course, many of you here in the audience probably could tell your own stories, and that works out quite well because after the event we will have a reception where we'll have an opportunity to share those stories. Now, another thing that I learned is usually when you plan an event, you plan and then you might downsize the room because you don't want the room to be empty. In this case, we actually had to upsize the room. We had planned, you might have noticed this was called a seminar, and that's the way we envisaged it. And it turns out that we are having the seminar today in the faculty's moot court room, and that really is, again, a reflection of Marty's outsized footprint. So we have a wonderful panel of distinguished speakers here for you today. I've asked them each to speak for 15 minutes only, bearing in mind again that much more could be said. I'll be a strict timekeeper. They've all been forewarned. And so what I want to do is to introduce them in the order in which they will be speaking, and then we'll take it from there. So our first speaker will be Professor Mayo Moran, who's the Provost and Vice Chancellor of Trinity College and also one of my predecessors as Dean of our faculty. Professor Moran has published extensively on comparative constitutional law, legal and feminist theory, and historical injustices among many other topics. And in addition to numerous awards, in 2012, she received the YWCA Women of Distinction Award. She'll be speaking to us about Martin Friedland and Kennedy's vision of legal scholarship. Next will be the Honorable Robert Sharp, who was a judge on the Court of Appeal for Ontario from 1999 to 2020, and now is Distinguished Jurist in Residence at the faculty. He too served as Dean of the faculty, as did Marty, of course, and we'll get to that as well. Bob serves as President of the Osgood Society for Canadian Legal History, and so fittingly, he'll speak to us about Martin Friedland and legal history. We'll then go to Professor Kent Roach, a preeminent scholar of constitutional law, criminal law, and national security and anti-terrorism law. He's won countless awards and honors. His appointment to the Order of Canada in 2016 and the prestigious Molson Prize for Social Sciences and Humanities in 2017 are but two examples. He'll speak on Martin Friedland and criminal law. Our next speaker is Mr. Justice Paul Chabas, who has served on the Ontario Superior Court of Justice since 2019. He was previously a senior litigation partner at Blake, Cassels & Graydon, where he handled a wide range of cases from complex commercial cases, including tax and class action matters, to constitutional and administrative law. From 2016 to 2018, he served as treasurer of the Law Society of Ontario. He will be speaking to us on Martin Friedland and public service. And last, but most definitely not least, Robert Pritchard. Where to begin? Rob taught at the faculty from 1976 to 2001. He went on to serve as dean. I don't know whether there's a theme here, perhaps to some extent. He then, of course, went on to serve as president of the University of Toronto. He's currently the non-executive chairman of Tories. He's served as director on the boards of numerous companies and organizations. He's an officer of the Order of Canada and a member of the Order of Ontario, again, to name but a few of his many honors. Who better to speak on Martin Friedland and the University of Toronto? So I'm about to turn it over to this wonderful panel, but before I do that, we actually have a special message for Martin Friedland from the Honorable David Lametti, Minister of Justice and Attorney General of Canada.
Marty, sorry I couldn't be with you in Toronto today to celebrate your 90th. What a fantastic achievement amongst all of your other achievements. The summer that I worked for you way back, I learned so much about pensions, something that I've tucked away in the back of my brain and I've used quite a bit, both in real life and after having become an MP. But what I'll remember most, and what I always remember most in terms of our ongoing friendship and your mentorship, has been your inquisitive nature. Anybody who knows you knows this. Anybody who has seen you interact with a gardener at Oriel College, Oxford, or with a cab driver, or with anybody else, sees that gentle, inquisitive nature, asking sincere questions, and really pushing people gently to tell you something that you really wanted to know. It was a pleasure to have watched you do that on so many occasions, and it's something that I've carried with me from you, and I've always appreciated that. And it was also built on a fundamental respect of who your interlocutor was, and I think that that's such an important part, Marty, of who you are. Congratulations on this. Congratulations to Judy for having put up with you for all of these years, and I really, again, I'm sorry that I can't be there. Just mazel tov, fantastic. Hope you have a fantastic party and a fantastic celebration.
Hello, everyone, and thank you so much. I'm thrilled to be here, Marty.
Sorry, I couldn't be
This is going to happen the whole time. I'm feeling a little wary about approaching the mic. Okay. I know I was in law school with David, so I know he's going to break in again. My connection to Marty began as a doctoral student and then as a junior faculty member. And during both of those roles, I often sought Marty's advice. He was known to be generous to those of us who were far more junior than him and who needed his help and guidance. But my deeper connection with Marty, of course, really began when I was dean, and he was the only other dean in the building. And so as soon as I was announced, Marty phoned me. And he said, "Can I take you out for lunch?" And so I said, "Sure, I'll book a restaurant." And he said, "No, I will take you to my special table at the Intercontinental Hotel, where I know that every conversation can be held in complete confidence. No one can see you, no one can hear what you're saying. And indeed he did. And during the nearly 9 years I served as dean, Marty was just invariably such a wise advisor, generous, smart, and wonderful, with one exception: faculty offices. So when I went to Marty to talk about faculty offices, the former deans in the building are all laughing because they know all about this. I said, could I ask you about faculty offices? And he said, maybe you should read an article by Rod MacDonald, who had been dean of McGill Law School, in the University of Toronto Law Journal. It's called Faculty Office Politics. And so I thought, okay, I went and read the article. Rod began the article by saying, the characters portrayed in this article are entirely fictitious, and any resemblance they bear to my colleagues at McGill is purely fortuitous. He went on to talk about all the intricacies of office politics, and in his characteristically elegant way, Marty had warned me about the quagmire of office politics, and indeed I stepped into it. I still stepped into it, but a little more gingerly, Marty, than I might have without your guidance. But I'm so pleased to be able to talk about Marty and his incredible career, and in particular, his foundational role at the law school. And I think it's especially fitting, and I'm grateful that I was asked to do so through the prism of his fantastic biography of the very enigmatic W.P.M. Kennedy. Not even his initials are unenigmatic. W.P.M. had many points of similarity with Marty, and being asked to do this talk, one of the reasons I'm grateful is I got to reread the biography and totally enjoyed it, and gave me a chance to reflect on what these two incredibly key characters in the history of our law school have in common, beyond the interesting fact that Marty and Judy in 1983 bought the Kennedy family cottage, and they found a trunk of materials in that cottage that helped to shape the biography that Marty wrote decades later. So what's the similarity between these two people? Well, for one thing, I would describe them as two Renaissance men who were both critical in building this great faculty at a very, very central point in its history. When Marty was made Companion of the Order of Canada in 2003, the citation said, his wide-ranging legal writings have been cited by the highest courts in Canada and abroad. In addition, he has played significant roles in government commissions and committees, and as a legal scholar and teacher, he has inspired a great many young lawyers and students. Truer words, Marty, were never spoken. A review of Marty's magisterial history of the University of Toronto described him, rather sadly, I think, as the university's last remaining humanist. I don't want to think that that part is true, but I do think that that description was a way of trying to capture Marty's unique combination of intellectual rigor, human insight, and his unmistakable literary verve. Just a number of the ways in which Marty followed in the footsteps of W.P.M. Kennedy and took up his mantle. Now, until Marty's biography, and I confess this is true for me too, Kennedy had mostly been in the shadow of the towering Caesar Wright, often described as the founding dean of the modern law school. But Marty makes clear just how much today's law school owed to Kennedy's energy and to his vision of law scholarship and legal education. The same can be said of the law school's debt to Marty Friedland. Both men were deeply engaged in what Oliver Wendell Holmes called the life of the law, and both helped to shape the law in vital areas through critically important policy work, and they did that the whole time they were law professors. Marty's biography of W.P.M. makes clear that he wasn't an isolated academic. He was instead deeply engaged in the issues of the day, and particularly, of course, the constitutional ones. As just one example, he worked tirelessly, and Marty chronicles this very well, to abolish appeals to the Privy Council, which he thought were humiliating for a country like Canada. Similarly, Marty, since his call to the bar in 1960, has, as Jutta said, engaged with such a wide array of important public policy issues that it's quite dazzling, actually. Everything, legal aid, gun control, securities regulation, judicial independence, national security, and that's only a few of the issues. And again, when he was initially named to the Order of Canada in 1990, the citation referred to the breadth of his intellectual vision and said that he had had an impact on the solution, not many of us can say that, to various social and criminal problems. Like W.P.M, Marty's involvement in the life of the law was not a sidebar. It was critical to understanding the forces that infused his scholarship and his teaching, and perhaps was part of the reason that the reviewer I mentioned referred to him as a humanist. Law, at the end of the day, as Marty makes clear, is a profoundly human institution with all of the strengths, the weaknesses, and, as Marty likes, the intrigues that implies. There's at least one critical difference, though. W.P.M was rather notorious for his attention-seeking behavior. He was inclined, particularly in his early career, to overstate his accomplishments, including his claims about drafting the Irish Constitution. Marty, by contrast, incredibly gracious and humble. And I must say that one of the other things I really enjoyed about being asked to do this talk was the fact that I got to look again at what Marty had done. And although I thought I knew, I was newly dazzled by both the breadth and the depth of what he's contributed. Now, another point of commonality, Marty and W.P.M were both outstanding teachers of the law. Both of them were beloved by their students and were often their students' biggest champions in ways that people may not have suspected. I remember that when I was dean, and Marty, you'll probably remember this, we had a book launch for your wonderful book, My Life in Crime and Other Academic Misadventures. And I was so struck by how many of Marty's students and research assistants came back to the law school, in many cases decades after they graduated, to celebrate with Marty. And so I'm not surprised that among his many other awards, he was a recipient of the Canadian Association of Law Teachers Teaching Award. Now, Kennedy, too, was a famously inspiring lecturer who often went above and beyond, and his talks and lectures were so renowned for their drama and their interest that, as Marty points out, he even managed to mesmerize his students while he was laying down on the couch in his office delivering lectures, something that, as far as I know, Marty didn't ever attempt. Come to think of it, I don't think you sang Wild Irish Rose at the end of your talks either. Now, in addition to all of this, of course, the scholarship was really, in many ways, a signature feature that I wanted to highlight. Marty's biography of Kennedy shows just how vital Kennedy was to the creation of the law school that I think we're so justly proud of today. At a time when the profession and the academy had contrasting views of legal education, W.P.M's strong commitment to law as a university subject critically won the day. Even the sometimes ungenerous Caesar Wright said that Kennedy, quote, kept the light of legal education glowing in this university when lesser men might have quailed. And for Kennedy, legal education entailed something more than just learning the rules, important though that was. He worked hard to attract people to the law school who were committed to a deeper understanding of scholarship. Kennedy himself had a capacious understanding of scholarship and left no doubt of its importance. And in the early days of the law faculty, he routinely admonished new faculty not to focus only on their teaching and to make sure that they paid attention to their scholarship. He, of course, himself was a committed and prolific scholar. Marty's impact on the scholarly character of the law school came at a similarly vital moment and really cannot be overstated. The Wright era had ended with the death of Caesar after 18 years as dean, apparently one of the reasons why term limits were brought in for deans. In the late 1960s, this wonderful law school was not in good shape. In 1969, Claude Bissell, then president of the University of Toronto, wrote to the faculty to warn them that they were falling behind in academic quality and asking them whether they were going to abandon the whole enterprise. But a bright future was ensured when, in 1972, young Marty Friedland became dean. His own scholarly credentials, beginning with his Cambridge doctorate and his wonderful OUP book on double jeopardy, which is still cited, signaled the importance that he would play on the scholarly enterprise. Equally important was that his conception of that enterprise was also very capacious. The academic excellence and the interdisciplinary bent that the law school is known for today is deeply intertwined with the way that Marty took up the mantle that W.P.M. had brought about in the founding days of this institution. One last comparison, the literary turn. W.P.M. was well known for his literary turn of phrase and his ability to make almost anything fascinating. One person described him as an absolutely mad Irishman who could make the law come alive. Now, I wouldn't apply all of that description to Marty, but he is known for his ability to bring the law alive. My favorite example isn't the literary ones, although they are wonderful, but in a review of his history of the University of Toronto, one reviewer candidly admitted that every reader approaches such books with a sense of dread. As he said, from the diverse, sprawling character of both subject and sources, a history of the University of Toronto was almost bound to be a lumpish catalog, ponderous but superficial. But to the reviewer's delight, Marty was none of these things. Indeed, the reviewer compared Marty to Virgil and said that unlike most writers, Marty wrote like he wanted to be read, and read he is. There's much more I could say, but I won't. I want to close with another odd little coincidence. At the beginning of his biography of Kennedy, as I mentioned, Marty notes that the family bought the Kennedy cottage in 1983. And it turns out that I too have a connection to that cottage, although unlike Marty and Judy, I did not buy it. But in a strange coincidence, and we'll see if we can get the image up here, several years ago, we purchased a beautiful little painting from an artist we greatly admire, Nancy Friedland. Yes, the daughter of Marty and Judy. The painting, which I will ask to be put up, you can imagine it if, do you want to, I don't know, Dave Lametti might come back if I step away. Okay, in a strange coincidence, we purchased this painting by Nancy. We absolutely love it. And as you can see, it shows two canoeists paddling in a beautiful cove. I knew when we bought it that one of the canoeists was Marty. Judy, is the other one you? I thought it probably was. And of course, that gave extra meaning to it for us, and we always loved the painting. But what I didn't know was that they were actually canoeing in that painting on the property that they bought from Kennedy, who, of course, strangely, is my more distant predecessor as dean of this law school. So Marty, thank you so much for all that you've done to build this wonderful place. I now will treasure your daughter's beautiful painting even more. Happy birthday.
Thank you so much, Mayo. That was a wonderful start. The interruptions notwithstanding, you took them in stride, but it sounds like you were used to them, and I'll turn it over to Bob Sharp.
Thank you. I first met Marty Friedland in September 1966 when I was a student in his first year criminal law class. I guess he wasn't not even halfway there to 90. It was clear to us that he was a dedicated scholar. He just published his important and pioneering empirical study on bail, detention before trial, and he was hard at work at getting his Cambridge doctoral thesis, Double Jeopardy, ready for publication. Rumor had it that he and his team of research assistants were scouring every single book in the law library to make sure that no reference to double jeopardy had been missed. Marty had a delightfully quirky teaching style, perhaps best exemplified when he tried to explain the criminal law lessons that could be learned from a children's book called Ant and Bee. No doubt he'd been reading Ant and Bee to young Tom the night before. It was clear from this that he was always on the lookout for novel approaches to the study of criminal law. My assignment is to tell you about one that proved to be considerably more successful than his Ant and Bee experiment. In his memoir, Marty tells us how he accidentally stumbled into legal history when he was on sabbatical working on a study of the codification of the criminal law. He came across a reference to a forgotten chapter in the history of codification, a draft penal code written by a young barrister, R.S. Wright, a prize-winning classical scholar and fellow of Oriel College, Oxford. Marty's curiosity was piqued. He ventured into the archives and he became fascinated by what he found. After much digging, he emerged with what he describes as his favorite article, R.S. Wright's Model Criminal Code, a forgotten chapter in the history of the criminal law. Wright was a liberal-minded lawyer, and his draft code, enlightened by the standards of today, proved to be a little too liberal and left-leaning for the Colonial Office and the British legal establishment. Sir James Fitzjames Stevens, then a senior barrister, was asked to revise Wright's draft. Stephen, the brother of literary figure Leslie Stephen and uncle of Virginia Woolf, did not share the avant-garde ideas of his literary relatives. Rather than revise Wright's draft, he set to work on a much more authoritarian and conservative code. And regrettably, it is Stephen's draft code that gained favor and was adopted widely in the Commonwealth, including, of course, here in Canada. Now, like his other work in legal history, Marty skillfully used the story of these rival codes to explore fundamental issues in criminal law. His method is that by telling the story of one incident or one case and paying close attention to its social and political context, we can better understand what seem to be abstract legal issues. Should the criminal law enforce morality? Stephen wrote a book disagreeing with John Stuart Mill's on liberty. Not surprisingly, the Stephen Code took a tough stand, harshly punishing homosexual conduct, abortion, and attempted suicide. Wright's code was considerably less harsh on those issues. And having adopted the Stephen Code in the 1890s, we're still, to some extent, struggling to escape the impact of his moralistic approach. Wright's code eliminated common law offenses, while Stevens retained them, including common law conspiracy, a weapon used with great effect to quell the rising labor movement, a weapon that Wright thought should be tamed, and it was clear that Marty agreed with Wright. Wright wanted to give judges more direction on one of the most important issues in the criminal law, the mental element in crime. Wright's code foreshadowed the sophisticated American Model Penal Code, carefully defining various levels of intent and specifying the level applicable to each offense. Stephen preferred to give judges discretion, and he refused to specify the required level of intent. And in Canada, we live today with his unfortunate legacy, with that unfortunate legacy of a large and difficult body of judge-made case law on this central issue in criminal law. Since the publication of the R.S. Wright article, Marty has continued to harbor healthy skepticism. I don't take it personally. Healthy skepticism of judges. He favors clear legislative guidelines on most issues, including the mental element in crime. Needless to say, at our frequent lunches, Marty and I frequently discuss that very issue. Now, a full list of the differences between these draft codes reads a bit like the syllabus for my first-year criminal law class. By exploring the differences in the two codes and explaining the forces that produced Wright's and Stephen's conflicting views, Marty's foray into legal history showed us the advantages at looking at the law from a different perspective. The lens of history allows us to focus on and perceive familiar legal issues in new and unfamiliar ways. Marty shows how merit does not always prevail, and that, to use his word, politics, personalities, and pressure groups sometimes determine outcomes. The Wright article and the experience of uncovering forgotten but significant events through archival work had a significant impact on Marty's future scholarship. He proceeded to write 3 highly readable, engaging, and revealing case studies, one English, one Canadian, and one American, each book exploring a long-forgotten murder case that was front-page news at the time it occurred. All lawyers trained in the common law tradition, most of the people in this room, are familiar with one form of the case study method. We cut our teeth by carefully dissecting the facts of reported cases and debating how the result might be different if this fact or that fact changed. But the case study method, familiar to all of us, reflects, in fact, a very sterile view of legal history. When lawyers look back to find the past precedents, they ordinarily restrict their reading to what can be found in the reported decisions. The decisional facts are often very detailed and provide a thorough account of who did what to whom, but as Marty's work shows, every decision is rooted not only in decisional facts, but is also the product of the prevailing social, economic, and political context. We can gain a richer understanding of the law, its content, and its development if we pay attention to the context in which these disputes arise and cases are decided. Marty's first case study, the trials of Israel Lipski, involved the trial of a Polish Jew for a murder committed in East London in the late 1890s. The judge was none other than Sir James Fitzjames Stevens. The themes of the book, the frailty of the criminal process, the risk of wrongful conviction, the effect of racism, the influence of the media, the perils of capital punishment, are brilliantly examined in a way that resonates today. As one often finds in Marty's books, the Lipski case had some unexpected twists and turns. Marty provides evidence of a possible link to the infamous Jack the Ripper. He uncovered archival evidence that the austere and moralistic Justice Stephen was actually smoking opium in the evening after he sat in court. He also uncovered a very revealing letter that Stephen wrote to his wife stating, and I quote, "The man was not quite properly defended," the man being Lipski, was not quite properly defended, and listen to this, "I myself did not exactly hit the right note in summing up." Looking at a case like Lipski and its historical context, in Marty's words, one can better understand some of the factors that may influence any criminal trial: the personality of the judge, the adequacy of counsel, the reaction of the press, the cry of popular opinion, and the vulnerability of the government, and many more. The book was very well received and won the Crime Writers' Prize for Fiction. A favorable review appeared in the Sunday Times, written by none other than John Mortimer, barrister and author of Rumpole of the Bailey. Marty's second case study was that of Valentine Shortis, who was charged with murder in Valleyfield, Quebec in 1895. Like Lipski, the Shortis case was sensational at the time, and but for Marty's book, would be forgotten today. Shortis, an Irish immigrant, shot and killed a man in a botched robbery. There was no question he had pulled the trigger. The issue at his trial was whether he had the defense of insanity. The very narrow scope that prevailed at the time for that defense in the criminal code turned on the use of the word "and" rather than "or," and that was made almost impossible for Lipski to overcome the limitation. Marty argues that that wording was likely the slip of a legislative draftsman's pen. It took the intervention of Lady Aberdeen, wife of the Governor General, to secure reprieve and commutation of the death sentence to life imprisonment. The Conservative Cabinet's decision to grant reprieve was unpopular, and Marty found strong evidence to suggest that it influenced the outcome of the 1896 election that elected Wilfrid Laurier as Prime Minister of Canada. Shortis spent 42 years in prison after the commutation. When he was released in 1937, he held the record for the longest-serving prisoner in Canadian history. Always the innovative scholar, Marty used that history to trace the history of many of Canada's legal penal institutions. It allowed him to order a short history of corrections in Canada, and he concluded, like other aspects of the justice system, our prison system is not the inevitable product of logical progression, but rather the result of, and I quote, accidents, economic factors, the desire to use existing structures, and the shifting demands of popular opinion. The Shortis book, like the other books, illustrates the contingency of law, the frailty of our the frailty of our criminal justice process. Shortest's fate was determined, at least in part, by non-legal but highly influential human factors: a drafting error, popular opinion, the media, rivalries between the lawyers, and the influence of the wife of the Governor General. Marty's third case study took him to the United States, involved the 1902 trial of a lawyer, Albert Patrick, for the murder of a very wealthy man, William Marsh Rice, the founder of Rice University, who had apparently died from poisoning. Suspicion immediately focused on Patrick when he produced a will that he had drafted that just happened to make him Rice's beneficiary. Again, the case was high profile at the time, but largely forgotten until Marty turned his attention to it. Marty found a treasure trove of previously unexamined archival records at Rice University, and he traveled across the United States to uncover other sources for his study of the case. Now, when I've told you that Patrick drafted the disputed will that made him the victim's beneficiary, and he also argued at his trial that Rice had died not from poisoning, but from eating too many bananas. You may think you don't have to hear any more, but no Friedland book could ever be so predictable. Ever the diligent and innovative researcher, Marty arranged to attend an embalming so he could understand some critical post-conviction evidence. Marty describes his legal history trilogy as follows. The Lipsky story is one of class and prejudice in England. Shortest is about race and religion in Canada. And the Patrick Rice case is about wealth and ambition in the United States. Together, they represent a notable contribution to our understanding of our legal past. Let me conclude by wishing you a very happy birthday, Marty. Happy 90th birthday. Thanking you for what you've taught me, for your friendship and your mentorship since I was a law student. And I want to congratulate you as well on your forthcoming book. Believe it or not, he has a forthcoming book that again uses the case study method to trace the history of Canadian criminal law from Confederation to present. I'm very much looking forward to the publication of that book, and I hope there will be more to follow. Thank you.
Thank you so much, Bob. That was wonderful, and I have a feeling that there's going to be a run on a trilogy of books, so watch out various purveyors, and I'll turn it over to Kent Roach for some reflections on criminal law.
Thank you. It's a great honor to address Marty's contributions to criminal law. Criminal law, in a sense, is a misnomer because Marty's work has spanned the breadth of criminal justice and beyond. Evidence, procedure, sentencing, the trial process, courts, comparative law, socio-legal, criminological studies, and constitutional law are all part of criminal justice as Marty has studied and taught it. This holistic vision of the criminal process is represented by cases and materials on criminal law and procedure, Marty's innovative and influential teaching materials. The broad approach to criminal justice that he sets out there continues to thrive, and it served Marty very well over the years as his scholarship adopted to many new subjects and the evolving challenges faced by our legal system and especially our criminal justice system. For this occasion, I reread Marty's first book, Detention Before Trial, published by U.T. Press in 1965. The book is as fresh and relevant today. It's hard to believe it was published 60 years later. Indeed, I found in the book, and it kind of annoyed me because I thought I was onto something, a discussion of what is the hottest topic right now in wrongful conviction scholarship. That is the danger of guilty plea wrongful convictions when accused are denied bail and can be released by pleading guilty, sometimes even at their first court appearance. Marty knew that 60 years ago, and we're only starting really to try to catch up. Detention Before Trial inspired the Bail Reform Act, and Marty has returned to the topic to criticize departures from the original vision of this act. The courts have recognized the wisdom of Marty's policy advice. The book has been cited at least 8 times. I say at least because I know Marty will have a better count than I, by the Supreme Court. Starting with Chief Justice Laskin's strong dissent in the 1973 case of Adjie. that, if it had been followed, would have brought order to our guilty plea process. And most recently, in the landmark Zora case written by Justice Sheila Martin in 2020. There's one line in Detention Before Trial that summarizes much of Marty's approach. Quote, "Law in practice is far removed from law in theory." Marty's approach to the law in practice has provided a direct pipeline from this faculty to courts and parliaments again and again. Marty's next major work was Double Jeopardy. The book has been cited at least 10 times by the Supreme Court of Canada, most recently 2019. Marty's work never goes out of style. Marty has kept up with the topic and has successfully warned Canadians against adopting a 2003 English reform that allows double jeopardy to be abridged. He relates this doctrine of double jeopardy to protecting the innocent from being convicted or pleading guilty while innocent because they do not have the state's, quote, stamina and resources. Canadian courts have responded to Marty's pointed critique that they had, quote, completely abdicated their role in protecting the accused from vexatious prosecutions. Marty has made important contributions to the study of Canadian courts. His 1995 monograph, A Place Apart, has been cited over 40 times by Canadian courts. My favorite Marty articles, in part because they're published in the CLQ, which I have the privilege to edit, are his study for the 1969 Ouimet Commission that documented the poor conditions in then magistrates' courts, and his 2008 revisitation finding many improvements. As with his work on bail and policing, not to mention drinking and TTCing, you remember that night, Marty, or embalming, Marty is a true believer in on-site visits. And in fact, when I was a research assistant for the Shortest book, we had a great visit to Guelph, to a prison where Mr. Shortest was in prison. Like his 1965 criticisms of the highly punitive atmosphere in police lockups and remand, a concern about equality and justice is never far from the surface, including in Marty's ongoing work. In fact, the CLQ has been very fortunate to publish preliminary versions of the chapters on Louis Riel and Stephen Trescott, but please buy the book or I'll hear it from Marty. Marty has always been concerned about miscarriages of justice long before the DNA revolution. In the 1960s, he went on television to argue that capital punishment should be abolished because the, quote, irrevocable death penalty should only be imposed by an infallible tribunal, and there was always a danger of miscarriage of justice. If that sounds familiar, it is precisely the reasoning that the Supreme Court of Canada, including Justice Iacobucci, who's with us today, adopted in the 2001 Burns and Raffe case. Marty featured the Stephen Trescott case in his innovative teaching materials, and I know he was very proud, Nancy, that you played a role in Trescott's eventual acquittal, as indeed Marty had played a role in supporting G. Arthur Martin in the 1967 reference case. I want to quote what I think is the most quoted statement by Marty. We include it in our updated versions of his teaching materials. And it goes back to this theory and practice that I spoke about before. Marty has wrote, and I think he likes this quote because he's repeated it a couple of times in his writing, "A trial in theory may be an objective pursuit of truth, but in practice there are many subjective factors which influence the course of events. Justice in theory may be blind, but in practice she has altogether too human a perspective." The True Crime trilogy reveals Marty as an excellent and engaging writer, and it also demonstrates his ease moving between the American, Canadian, and English trial process. Indeed, you find that ease in comparative law in Double Jeopardy, published in 1969. One final topic that should be mentioned is Marty's contributions and approach to the Charter. Marty played a role in the Canadian Jewish Congress's submissions that helped draft and form the Charter. In the 40 years since, he has shrewdly viewed the Charter through a legal process lens that recognizes that while courts have important roles, so too do the legislature and the executive. As in many other matters, it has taken me some time, Marty, to appreciate the wisdom of your approach. You've been very patient with me, and I thank you for that. There are many good charter decisions that promote restraint in the use of criminal law, recognize the danger of wrongful convictions, the death penalty, and double jeopardy, three things that Marty has fought against his whole life. That said, I agree with Marty that Parliament has become too reactive to the court, and there is a sense that the minimum standards of fairness that the courts protect under the Charter have become maximum standards. Marty, you've set an extraordinary standard in the breadth and depth of your scholarly interests for all of us who are trying to follow in your large footsteps. Happy birthday.
Thank you so much for those reflections, Kent and Mr. Justice Chavez.
Well, I too am delighted and frankly feel very privileged to be here among such a distinguished group as we recognize the contributions of our teacher, our colleague, our mentor, our friend, Marty Friedland. I was Marty's research assistant back when Marty was a mere 50 or so. You can do the math. As his wonderful memoir, My Life in Crime and Other Academic Adventures, and sorry, I had to laugh at Bayo's slip. I think she said misadventures.
I was a D.
Fair enough. As that memoir notes, Marty has had over 100 research assistants. I've encountered many of them over the years. Several were or still are at Blake's, where I practiced. And of course, they turn up in all areas of practice. As a judge, I now find colleagues at the court who worked for Marty, some of whom are here today or joining us online. I suspect that all of us who worked for Marty feel a sense of pride that we were chosen by him. Marty was always generous with his time, collaborative in his work, and ensured we had rewarding experiences. He used to take us to lunch at the old Cake Master Cafe for sandwiches on Cumberland. It's not as fancy as the Intercontinental, I'm sure. And some years ago, I'm not sure how long, Marty, you held a reception for all of your research assistants at Flavel House. I think 20, 25 years ago when you were, 65 or 70? Just a spring chicken. It was a lovely event, and it reflected Marty's enjoyment of working with his students and his ongoing interest in what we were all doing. Marty was, of course, a popular and well-liked professor. He has, as we know, a friendly and engaging teaching style with a good dose of humor, which was much appreciated in my day. I must say I don't remember Anton B., but we've moved on from there. But I do think of him holding his glasses as he taught, as much a prop as an aid, using them to emphasize two sides of every issue. I mean, for those of you who took his course, you can see him on the one hand, on the other hand. And I enjoy seeing Marty holding them in Joanne Todd's wonderful portrait of him, which is reproduced on the cover of his memoir. I think he's got one of the earpieces in his mouth. As Kent has highlighted, much of Marty's work has been on issues of current public interest and has involved law reform. My task today is to speak about Marty's public-facing work, and I will focus on Marty's work as a law reformer. Marty was very active in pressing the federal government to create the Law Reform Commission in Canada in the late 1960s. In 1971, Marty was one of a group of young tigers, as then Justice Minister John Turner called them, appointed by Turner to be the original commissioners. Other tigers included Antonio Lemaire and Patrick Hart. Marty's time in Ottawa was brief, however, as he was lured back to Toronto by the dean's job here a year later. Nevertheless, he had a strong influence on the direction of the commission in its early years, and he continued to work with it on a number of projects. One of those projects, which Marty has come back to from time to time, has been on enhancing public access to and understanding of the law. Marty pressed the commission to look at ways to make the law available to the public and to be in plain language. Today, we all accept this as a worthy, indeed important objective, and there are many organizations and resources that make law accessible. But this was not the case in the 60s and 70s. As Marty recalled in his memoir, when his proposals attracted media attention, lawyers and judges were divided on the issue. Peter Corey, then a bencher of the Law Society, thought it a good idea. But Bora Laskin, by then the Chief Justice of Canada, expressed skepticism about people researching their own legal problems. Marty's old friend, the distinguished lawyer Earl Cherniak, who is here today, and forgive me, Earl, you're a friend of mine too, but it's in the memoir, said that Marty's idea was, quote, the dumbest thing I ever read. Marty then produced a multidisciplinary book, Access to the Law, which included reviewing how people access legal information and the barriers they faced in doing so. I am sure it was the first study of its kind on that topic in Canada. In the late 70s, Marty turned his attention to national security. The MacDonald Commission inquiry into RCMP wrongdoing, RCMP activities was created in 1980. I preempted my joke, or Marty's joke. After it was shown, as Marty colorfully put it in a speech at the time, that, quote, the Mounties had not been spending all their time perfecting their much heralded musical ride. The commission asked Marty to prepare a background study which was published under the title National Security, the Legal Dimensions. Marty began that book somewhat cheekily, as he has acknowledged, stating, quote, I do not know what national security means, but then neither does the government. But Marty's study was influential. However, as Marty did know that whatever national security meant, there was a need to have transparency and clarity around the use of police and security service powers, and that the judiciary should play an important role in checking the powers of the state to ensure that civil liberties are respected. In this context, I'm sure Marty is watching with interest the current inquiry into the recent use of the Emergencies Act. Around the same time, Marty took on gun control, authoring an important paper supporting strict controls on the possession of handguns in Canada, and he spoke out publicly on the issue. Later, as Kent mentioned, he wrote an important study on judicial independence, a place apart, judicial independence and accountability, that is regularly cited in the rather robust jurisprudence on that topic. And he returned to national security in his work on the 2001 Anti-Terrorism Act, again warning of the need for judicial oversight of covert activities. With his students, Marty also worked to promote law reform. In 1983, he created the Law Review seminar course in which students wrote papers on areas of criminal law that were ripe for reform. The papers were subsequently published in an edition of the Faculty of Law Review. I was in the first class. Marty obtained funding to take us to Ottawa, and over 2 days, our seminar group met privately with Mark McGuigan, then the Minister of Justice, Bob Kaplan, the Solicitor General, experts at the Law Reform Commission of Canada and the Department of Justice, and we had an hour or so sitting around a table discussing criminal law with Brian Dixon. It was memorable and remarkable how Marty opened those doors to us. I'd like to add to Kent's remarks on detention before trial. When I hear bail applications, I am regularly reminded of Marty's book. It remains the starting point for the leading decisions on bail in the Supreme Court, including, as Kent mentioned, the recent decision in Zora, but also the decisions that we refer to all the time in bail cases, Antic and Myers. I think we would be hard-pressed to find a work that had such a tangible impact on reforming one area of the law and which continues to carry such influence almost 60 years later. But what also makes detention before trial significant for illustrating Marty's public work is that it was based on factual research. Marty, like all good lawyers, knows that facts matter. He met with crowns, magistrates, administrators, police officers, and others to understand the bail system. He gathered data on remands and releases, time spent in custody, amounts set for bail, delays, and of course, the relationship between not getting bail and the guilty pleas that frequently follow. This wasn't about legal theory, it was about people, procedures, and liberty of the subject at a very grassroots level, and it was irrefutable. I also recall Marty's concern that the Charter might limit the continued role of legislative change in criminal law. Marty wrote about this in 1983, just after the Charter had come into force. In his book, A Century of Criminal Justice, Marty warned of, quote, the danger in constitutionalizing the ordinary criminal law, end of quotes, in part because of the concern that law reform should proceed as a matter of policy and not be driven by activist courts. I was working with Marty when he wrote that, and I have often thought of his comment. I don't know if Marty feels his warning has been heeded or whether what he feared has come to pass, but his identification of the concern was, like so much of his work, thought-provoking, practical, and important. There is, of course, much more I could say. Marty worked in many other areas of law reform in the public interest, but time does not permit it. So in closing, I would like to thank Dean Brunet for inviting me and giving me the opportunity to speak about Marty's extraordinary work and his legacy as we celebrate his 90th birthday, and to give my own thanks to Marty, who has been a mentor and friend to me for the past 40 years. Thank you very much.
Thank you so much. And last not least, Rob Pritchard.
I first met Marty 50 years ago last month in this room. His first day as dean and my first day as a law student. So it's good to be back in this good place. My assignment today is different than the other panelists, and I am to speak about Marty's impact on the University of Toronto. Marty's been a part of the University of Toronto for the past 72 years, albeit with very few short flirtations away at Cambridge, Osgoode, Kimberdubbin, and the Law Reform Commission of Canada. That's a long run, long enough for a couple of careers at least. It spans over a third of the entire history of the University of Toronto. Marty's been a student leader, a scholar, teacher, dean, presidential advisor, university professor, and university historian, and he's been highly accomplished in all these roles. Marty's not only been important to the University of Toronto, he's been important in my life. He was my dean when I was a law student, my employer when he invited me to join the faculty, my colleague when we served together as professors, my trusted advisor when I needed his wise counsel as president, and my friend and summer neighbor in the Kennedy neighborhood. I'm grateful for his confidence and support over the past half-century. My fellow panelists have focused on Marty's scholarly and public policy contributions, marking him as one of the leading scholars of his generation. And that alone, of course, is worthy of this symposium. But I want to add to that record Marty's impact on the University of Toronto itself. The university is a great institution, Canada's best, and now consistently ranked as one of the world's finest. Indeed, just last week, U of T was ranked as the world's 18th best university anywhere, first in Canada and second among all public universities in North America. It holds that special status in substantial part because of colleagues like Marty, who are not only outstanding in their chosen fields, but who also care deeply about the institution itself and make large and lasting contributions to advancing its greatness. Marty stands tall as among those who have done just that. Marty was a university leader from an early stage, elected president of the LIT, the University College Literary and Athletic Society, which is the college's student government and the oldest democratically elected student government in Canada. That began involvement in university affairs that transcended his own work and was manifested in multiple ways in the 7 decades since. In my written remarks prepared, I focused on 4 of his many contributions: university governance, decanal leadership, the University of Toronto Press, and university historian. But Mayo has already well covered Marty's outstanding leadership as dean, so I will omit that portion of my prepared remarks. University governance. Marty joined the university faculty in 1965, and it was not long before he was asked to play a university-wide role. It was a challenging time at the university as the late 1960s brought revolutionary change to universities around the world, and the University of Toronto enjoyed no immunity. The president, Claude Bissell, was burdened with a traditional bicameral governance model, an antiquated board of governors increasingly distant from the mood of the campus, and a relatively ineffective Senate, as Bissell faced demands for change, demands amplified by a rapidly growing enrollment, the expansion to 3 campuses from 1, and the rise of student activism. President Bissell was a progressive visionary. he became convinced that a new model of governance was required to meet the demands of the new era, a model that would bridge the divisions among the external governors drawn largely from business, the increasingly engaged faculty, and the activist student leadership. He imagined not incremental reform, but radical change. Bissell began in 1965 by creating the President's Council, an advisory body to him consisting of leading university administrators and elected faculty members, plus some members of the Board of Governors. This council became the de facto governing body for the university in this transitional period, as the president relied heavily on it to guide the university through increasingly turbulent times. Professor Jim Milner of the law school was an initial elected member of the President's Council, but with his sudden passing in 1969, Marty was elected to take his place. This put Marty at the center of the action as the pace of change accelerated. The university had created a Commission on University Governance a year earlier to address the demands for a new model of governance that would accommodate demands for greater student and faculty involvement and create a new forum for all stakeholders, internal and external, could respect. This is not the time or place for a full history of this tumultuous time. Suffice it to say that the Commission recommended a new unicameral governing body with participation from all stakeholders to replace the historic bicameral board-senate arrangement, a change that would require legislative intervention at the provincial legislature. To deliver this change and to make a request to Queen's Park, the university needed to build a consensus about the competing interests when confrontation and not consensus was the temper of the times. To lead this process, the university turned to Marty. He first led a programming committee appointed by the president, which in turn recommended a constituent assembly known as the University-Wide Committee. The University-Wide Committee was later described as the largest, boldest, and most ambitious presidential advisory committee ever struck or likely to be struck in the history of the University of Toronto. And under Marty's leadership, it delivered. And with a consensus built on campus by Marty's work, the legislature then embraced the unicameral model, and in 1972, the university's new governance took effect. This was a fundamental change for the university, one which Bissell thought would pave the way for others to follow, as it provided a new model for university governance, which gave voice to all stakeholders in a single governing body to decide all the most critical issues facing the university. The Governing Council did bring relative peace to the University of Toronto, but virtually no other university in the world, anywhere, has followed the U of T model over the subsequent 50 years. Moreover, for the first 20 years following 1972, many viewed the unicameral model as a mistake, causing some to believe the university was, quote, unmanageable and ungovernable, leading to calls to return to the earlier bicameral model. But time has been kind to the unicameral model that Marty was so central in developing. Various adjustments were required to realize its full promise, but as we celebrate the 50th anniversary of the creation of the Governing Council this year, the university now thrives with a healthy and engaged governance process that has overseen the reassertion of the university's preeminence. Our governance is now seen as a strength, not a liability, a force for unity of purpose that respects and reinforces our academic mission and creates conditions for it to thrive. Marty played a seminal role in this very creative constitutional change. I'll omit the portion on Marty's decanal leadership, other than to say he was fantastically good. The University of Toronto Press. Great universities have university presses: Oxford, Cambridge, Harvard, Yale, Princeton, Chicago, and the like. It comes with the territory and responsibility of academic leadership. The University of Toronto Press has long been Canada's leading contributor to this field. Marty has published many of his books with UTP, but he's done much more than that. But he's been much more than an author. He's also played a key role in preserving the press as a highly regarded university publisher, which has sustained and advanced the University of Toronto's reputation as a whole. Maintaining a university press is not easy. Book publishing is a tough business, and academic book publishing is at the hard end of that hard business. In tough times for university finances, a common response is to cut back on the university press. U of T has faced these pressures repeatedly, but fortunately on each occasion the press has prevailed and continued, and Marty has been a key leader in making this happen. The most important question for the press is what to publish. That question is answered at the press by the Manuscript Review Committee. It requires a savvy combination of high academic standards and market insight. Marty combines these qualities beautifully, and as a result, he's been a central figure at the press throughout the modern era. Marty began serving on the Manuscript Review Committee of the Press in 1977, became vice chair in '83, and chair in 1995, I might say appointed by me, and served as chair until 2010, when he completed an extraordinary 33 years on the committee, almost a third of the entire life of the University of Toronto Press. And he also served on the board of the University of Toronto Press for 15 years. I can't claim that there wouldn't be a UTP today without Marty, but I can say that when the future of the press was in doubt in the early 1990s, and some advocated closing it to save money at a time the university faced major financial challenges, Marty's support for and deep involvement in the press was a crucial factor in the university's administration's decision to restructure the press instead of closing it and to put it on a new and renewed course. And the continuing vitality of the press is rightly part of Marty's legacy at the University of Toronto. And finally, the history of the University of Toronto. When I was appointed president of the university, my first thought was to read the history of the university so I would know it better. Unfortunately, no history of the university had been written in the previous 75 years. That struck me as a serious omission that should be corrected. There are challenges, however, in commissioning a history of your own university. You want a serious work of history, not a public relations piece. You need to avoid placing institutional pressure on the author to tell a story that the university administration would like, but at the same time, you seek a history that is likely to be judged as definitive, be respected by scholars, and be relatively free of an ideological agenda. You also need a book that will tell a story and be a compelling read, and not just be a collection of facts and documents. You want a book that will be read and enjoyed, and that will inspire with the great story it tells. It took us some time to settle on a plan, but fortunately, one of our vice presidents, Professor Michael Finlayson, who's here today, was a historian and a good one, and he guided us to a good solution. We agreed we would look to the University of Toronto Press as publisher to ensure high scholarly standards for the book. We also needed a process to choose the author of the book, a process independent of the administration, but one we could place our confidence in to make a wise choice. Fortunately, Father James McConaughey, president of St. Michael's University at the time, and an esteemed scholar who had recently edited a volume on the history of Oxford University, agreed to chair the selection committee. In the end, Marty was chosen. It was, of course, a brilliant choice. A university professor with a distinguished record in legal history, who loves archival research, knows the university well, and gets projects done. The latter was particularly important because we knew the task was vast, and we wanted to have the history published in time for the university's 175th anniversary in 2002. We wanted a finisher who would deliver, because an earlier effort decades before was never finished, as the volume of material had overwhelmed the author. Marty delivered in spades. He produced a landmark volume, acclaimed by all reviewers and fully worthy of the university, telling the story of our incredible journey from our earliest days to our current standing among the world's very finest. It's a magnificent work that so vindicated the selection committee's wise decision to turn to Marty for the assignment, and that erased the previous gaping omission in our history. So there you have it, a highly effective governance process for one of the world's finest universities, a thriving, globally respected law school, reflecting the highest standards and ambitions of the university, an academic press that stands proudly among the very best globally, and all of this recorded in a magisterial history of the university. Marty's hand lies at the heart of all of this. Happy birthday.
Thank Thank you, Rob, and thank you to all of you for painting this extraordinary tableau. And as we've said, all of us have said, and it's very obvious, still only scratching the surface. And if you're wondering whether this is setting a precedent for the faculty having birthday parties for every scholar who might reach a certain age, I think we're quite safe, because we're having an extraordinary and unique friend and colleague here. And I am delighted to say that he has agreed to also say a few words to us. So the floor is yours, Marty.
Thank you, Jutta. And thank you, all of you, for your very generous remarks. I'm overwhelmed with gratitude to be honored with this celebration and to have heard those kind words from good friends. As I look out there, I'm pleased to see so many friends, family members, former students, and colleagues here in person, and to know that many others are watching online. People being interviewed after a special event are often asked, what was going through your mind as you heard, etc. One thought, I must admit, is that I feel like Tom Sawyer attending his own funeral. So let me begin. I'll be short. I'm grateful for having a loving and supportive family. Judy has been an important part of the voyage and has had an equally rewarding career as an academic. Her memoirs are being published by the U of T Press in a few months, and you can read. And that will give further insights that may not have been mentioned here. And I'm proud of our 3 children and 8 grandchildren. I'll say something here about my early career becoming a law teacher. I won't go on to deaning or the other things mentioned here. I was lucky to have attended the University of Toronto Law School in the 1950s with excellent teachers such as Bora Laskin and Caesar Wright, and highly motivated students. The course attracted motivated students because full credit wasn't given to our LLBs, and so we had to spend an extra year at Osgood. Our class of about 35 students produced several law deans, including Harry Arthurs, a senator who's here, Jerry Grafstein, and a number of judges, including Chief Justice Julius Isaacs and Supreme Court Justice John Sapinka. Articling with Charles Dubin opened up the strong possibility of a career as a litigator. I never thought I would be an academic. My high school classmates would not have predicted it. As it turned out, however, I had good marks at law school and received a scholarship that allowed Judy and me to spend a year in England. Then, out of the blue, the Law Society offered to match that scholarship if I would come back and teach at Osgoode Hall Law School for just 1 year. I accepted the offer, which allowed us to purchase a red Sunbeam Alpine and tour the continent both summers. I would, I believe, join the Dublin law firm after teaching for that year. I enjoyed teaching and interacting with students. I also found the research I did on the bail system and other projects stimulating. I decided to return to Cambridge and do a doctorate and then go into practice. I should add that my thesis supervisor at Cambridge was the great legal scholar Glanville Williams, who influenced my scholarship both as a role model and also helped me as a writer. 1965 was a key year. I became involved in some important law reform projects that we've heard about. The Kimber Committee on Securities Regulation and the Ontario Joint Committee on Legal Aid. In both cases, the laws were subsequently changed. In 1965 was the year that my bail study, Detention Before Trial, was published by the University of Toronto Press. I found great satisfaction in being able to play a role in reforming the law. 1965 was also the year that I returned to my alma mater, the University of Toronto Law School. The bail study was important because I worked closely with statisticians and sociologists. This was my first foray into interdisciplinary research, which has shaped much of my work. The book also introduced me to the publication process, which continues to interest me. When Detention Before Trial was being typeset, I requested permission, which was granted, to watch the typesetter dropping the hot lead to form my words. I was told that I was the first person to ever request this. As Rob Pritchard has noted, my involvement with the U of T Press continued to be a significant aspect of my career. Through these early projects, I found that I could effectively use summer research assistants. Many of my former research assistants are here today, and many I know are online. I have had well over 150 very bright research assistants, including Kent Roach and Paul Shabas. Some of my recent research assistants are here too. Research assistants are a key reason why I have been a productive scholar. Throughout my career, the law school and its various administrations have actively supported my scholarly work. I'll stop there. The rest of my career had similar twists and turns. I can't think of how I could have had a more interesting and rewarding career. I have been very lucky. Thank you all for coming.
So we have, this is not to cut off the well-deserved applause, but we have the remarkable opportunity to have a conversation with Marty. We have about 10 minutes or so left, so if there are comments, questions from the floor, he is very happy to engage, and I'm sure others on the panel are as well. So please, there we go.
Okay. Jerry Grafstein. I should have credited the study group for the success of the members of the group. But times are different now. I tell students to have study, or I used to tell them to have study groups, how important it is. And what we particularly liked is the mothers prepared lunches for us. I'm not sure that they will do that today. Right. And even I see in the Morning Globe that there's a new book out on John Turner. I'll glance through it when I get it and see if you get a good, you're in the index. I'm sure you are.
Very good. So all the way in the back, please. Yes.
Speak up.
There comes a microphone.
My name is Angela Swan. I used to be John Swan. I joined U of T faculty the same year Marty did. We were the last but one, I think, appointments by Caesar Wright. Caesar Wright died in 1967. He was gravely upset by the university's decision to make deanships time limited. It infuriated him. I think Frank Iacobucci was his last appointment in that year. Marty became dean in 1972 after rather unsatisfactory interregnum with Ronnie MacDonald. I want to account as my experience as a junior faculty member, the impact that Marty had on us as a faculty. With Ronnie, you end up deeply disappointed. If I'd say to Ronnie, let's do this, Ronnie, he'd say, yes, yes, John, you're quite right, let's do that. If Marty said, let's do the opposite, he'd say to Marty, yes, you're quite right, let's do that. So he did nothing. Marty came in and somehow transformed the law school from a place of rather, not much happy, but kind of dull, into a really exciting place to be. We all felt moved to publish. I've watched Marty many years, with admiration for every summer. He did what every law faculty member should do. He published a major piece of work every year, and all of that. But the whole place, the whole atmosphere of the faculty was so transformed in Marty's years that I ended up, it was a wonderful place to be, and I enjoyed it very much. And my career, I think, has benefited from that. So thank you, Marty.
Well, I should mention, should have mentioned that the help I had from colleagues Angela, then John Swan, Frank Yacobucci, who had come in 67, I think it was, and was my associate dean. Dick Risk, who's here today, was a great help, and a couple of people I'll mention that were hired around that time, Michael Trebilco and Ernie Weinreb, who are not here, but I know are online. So I had some really great colleagues that would help me shape the law school. We would all shape the law school to be a more academic institution, not just a school that taught the practice of law. So thank you, Angela, for what you did at that time.
I think the microphone has already made a journey, and there's another hand up there. So.
Yes, my name is Earl Berger. I have known Marty longer than anybody else in this room because we went to Sunday school together. I guess we were 6 at the time.
Lift the microphone up a little.
I guess we were 6 at the time. So we went through high school together to Extensive University and so on. So I've been thinking about Marty's career a long time because I have followed it, of course, very closely. And I've always thought that Marty was, in a way, a deceptive person because he stands there and he looks like, and he is in many respects, a highly respectable academic. But there is a side to him which is, I think, the source of his great work. And I think the detention before trial was one of the major works in this country affecting the lives of thousands of people. Marty has, he's 2 steps to the side. When he looks at something, and maybe I'm talking to grad students now too, when he looks at something, although he doesn't say so, he's always looking at it from 2 steps to the side, and he sees it differently. So when you look at his research, you look at how he says his history of the University of Toronto, you see a mind that is ostensibly a really good mind, an excellent mind, but it is slightly to the side, and that's where I think his great insights come from. I have to tell you that when he was a child, I was never as good as him. He was a great marbles player. He knew, and that was a big thing in our time. He was a great marbles player because he knew how to place things. And I think for researchers and people examining the stuff of human life, to take 2 steps to the side the way Marty does, quietly, but looking at it that way, I think is an excellent way to go. I mean, there you are, my old friend. And it's just wonderful to see you here and to see the recognition that you so richly deserve.
Well, thank you. You're right. I think you are my oldest friend, or longest friend in the room. So thank you for those comments.
I think we have, okay, so 2 more. 1 and then 2, 3. Okay, so what can we say? 1, 2, 3. And maybe why don't we do them all in one go, and then Marty can respond.
That's a good idea.
Please.
My name is Dick Risk, and I want to echo what Angela said about Marty's deanship, because although the fact that he was a dean has been mentioned often, but none of our 4 speakers spoke in particular about his deanship. I was appointed in '62, and at that time, much of the work of the faculty consisted of writing headnotes for the DLR. If I was encouraged to do any scholarship at all, it would have been perhaps to produce a case book or at best a case comment. When Marty was appointed, the school had been drifting, and the change he made was remarkable. Scholarship was demanded. And I can remember, for example, one session in the dean's office, which he may or may not remember, when it was demanded of a colleague, do scholarship. And again, I think that was a crucial turning point in the faculty's history. So in short, I simply want to endorse everything you said.
My name is Charles Levy. I worked with Marty on the history of the University of Toronto. Robert Pritchard spoke eloquently on Marty's selection, and other scholars have spoken to Marty's legacy and how things he asks about have a way of resounding years after he asked. I won't recount the argument we had in his office about a footnote, but I will say his persistence of that footnote and a small piece in the Canadian Jewish News a year later led just recently to the University of Toronto Medical School apologizing for discriminating against Jewish medical students. If it had not been for Marty's dogged persistence, that footnote, that would never have happened.
Good.
Say, for the record, that I am the painter and she was the Truscott. Jenny was the Truscott. I couldn't do both. What's that? And B. That was Tom was and Tom was the. But what I just wanted to come back to what Dave Lametti said at the beginning, which was about my dad's curiosity and how I think he presented for us such a wonderful model of how to be in the world, and that to come into every situation with a kind of quiet confidence and curiosity, and that was such a wonderful thing to see in such an accomplished man who just presented, it set everyone at ease and let everyone be themselves. And so thank you for that.
I can hardly let my sister say something without also adding my own 2 words. I wasn't expecting to speak. In fact, Yuda said that as a McGill Law graduate, I wasn't allowed to speak, but they did let Mayo speak, so there you go. So I just want to say on behalf of the family to thank everybody for coming. There was a lot of angst over the last week or so about whether anybody would show up, who would show up, whether the speakers would perform adequately. So I just want to say on behalf of everybody that you all did an excellent job. Thank you. And to thank everyone for coming. And I was also going to comment on the inquisitiveness. That's what's led us to inquisitive lives, my sisters and me and our children, the 8 grandchildren. Plug for my favorite eldest son's video series as he explores biking from the BC Washington State border up to the Arctic last summer. And we had many experiences with inquisitiveness as children growing up, although I think many of them ended with my mother saying, "Are you sure that's not private property?" So, thank you.
Oh, here's a good test at 90. Can I remember what all the people said? But yes, Jenny was counsel in the Truscott case and is mentioned many times in that article that Kent is publishing. Nancy is the artist and has a show next week at Art Toronto. Is that what it's called?
Yes, Dad, it's called Art Toronto.
Art Toronto. And you can... And Tom is a good friend and was a classmate of Dave Lametti, and that came as a complete surprise to me. And the question is, did you know that he was doing it?
Almost as much as he tells Tony Clement.
Charles Levy illustrates the importance of having first-class research assistants. He was the chief researcher for the University of Toronto history. We had about 10 other researchers, almost all of whom were U of T law students. And so you did a part of the success that Rob and others have talked about is because of Charles and those research assistants. Finally, Dick Risk, those were nice remarks, and absolutely right. I haven't stressed enough here the importance of the members of the faculty when I became dean. Dick, unlike most, had unlike many, had a very good record of scholarship. And I think I appointed you as the head of the research committee, which brought in recommendations that we worked out together as to how we would encourage scholarship at the Faculty of Law. So once again, thank you very much.
Wonderful. And the best part is that we can now continue the conversation with Marty and about Marty, and I can see there is lots to be said yet. So we'll go from here to the Rowell Room and the area in the front of Flavelle House where there is a reception. A little bit after 6, we'll have some more remarks, very briefer ones, but more wonderful remarks. But between now and then, please go enjoy yourselves and mingle, and we'll see you there.